sub-article 3, paragraph...
Article 3 in the protocol.
Yes, of the protocol.
Could you read this Article 3 of the protocol, or if someone can read this article? I have it in my mobile, the protocol, so I will find it.
Okay.
Article 3, what is the topic of this article? What is the title of this Article 3? Okay, I have Article 3 with me. Could you read it, Article 3? It's 1, 2, 3. Yeah. Article 3, which paragraph? Scope of obligation, of application. Okay? Then, where do you find the definition of the territoriality in this article? Which paragraph? We have Article 3, it includes 1, 2, 3, 4, 5, 6 paragraphs. Tell us exactly where is the paragraph in order to follow you. All investment, okay, obligations. Which paragraph?
I'm trying to search it on my mobile phone, but if you can assist me.
Yeah, I can, but which? This is Article 3 of the protocol.
Okay.
Who has the protocol with him? Who has a computer? Come with him, show him the protocol. Oh, you have to move, better, come with him. This is in French, look at this. Could you help him?
Okay, I can read the article.
Yeah, please do it, yeah.
Article 3,
Yeah.
It's about scope of application.
Yeah.
And the article which I was referring is Article 3, sub-article 3.
Yes.
Which reads, the obligation of a state party under this protocol shall apply to measures adopted or maintained, paragraph A. It's central, regional, or local government or authorities. And paragraph B proceeds with non-governmental bodies when exercising powers delegated by central, regional, or local government or authorities.
Okay. Now let's move to the Tanzania-Switzerland BIT. Do you have with you the Tanzania-Switzerland BIT? Can you look to the definition of the territory of the state in this BIT? If someone has the BIT that we used it yesterday, can you read the definition of territory, please? Yes. Give her the mic, please.
Sorry. The term territory includes the maritime areas adjacent to the coast of the state concerned to the extent to which that state may exercise sovereign rights or jurisdiction in those areas according to international law.
So here you have a definition of what is the territory. And this convention provides that the territory includes all this area. Here, Article 3 did not give a definition of the territory. What is the meaning of the paragraph that we quote? The paragraph said that if there is a measures adopted by a local government, by a central government, or any other governmental body, the state will be responsible for that measures. There is no definition, no indication related to the territory. This is a definition, this is an issue of liability, is not an issue of territoriality. You see? So here in the protocol, in the African protocol, we don't have a definition of territory as the definition that we find in the bilateral investment treaty between Tanzania and Switzerland. In order to help you to understand the problem, I will give you an example. If you have an investment that was made by an African investor in another country, but it was in the maritime area, in the maritime space. The question is, this investment is protected or not by the protocol? When you read this paragraph, you don't find the answer. Because the paragraph that we read said that any measures adopted by the central, regional, local government is considered as measures adopted by the state. This is what we call the federal clause or the subnationals clause. That means that the state is responsible not only for its own behaviors, but also for the behaviors of any entities under its control. This is not an issue of territoriality. I hope that the issue now is clear. Is it clear for, do you agree with me that the protocol, until now, if someone finds this definition, you can start the exploration. You have till tomorrow. I am waiting for the definition. If you find this definition tomorrow, I am here to finish this course. So you have, again, 24 hours to find the definition of territoriality in the African Investment Protocol. But I did not find it. So it's not the same, it's the scope. As I told you yesterday, in order to fix the scope, you need 4 elements. You need the protected investors, the protected investment, the time, then the territory. The 4th element is missing. The protocol did not provide for that. I understand, I cannot say it because, okay, let's now move. I think that this issue is clear. Yesterday, we have a practical work related to the argument put forward in favor or against international investment agreement. So what are the arguments in favor and what are the arguments against the bilateral investment treaties and in general all the investment treaties? Who want to start? For or against? Who want to start? For, yes, please. Short argument, please. Huh? We don't have a conference. Excuse me, I'm really sorry because I am not against the debate, against the questions, but we have a program you have to finish. And if you open the door for the endless debate, we will not finish. You will speak, you know me. Everyone give his conference, and then we leave, and we did not finish the program. I am obliged to finish the program. That's why I try to restructure the debate. Short argument, for or against you. Give him the mic.
One argument for IIS has been the protection against arbitrary state action. Yeah. So true. Standards such as fair.
They protect investment. We need investment. It's good for the economy, so they protect. In favor. Second argument. Against. I think that, yes. Against or for? Yeah.
The asymmetry in investor-state dispute settlement in the sense that states cannot bring cases against investors.
Yes. They grant rights to the investor without offering the same rights or similar rights to the state. But that's the first generation. The second generation now of investment treaties takes into consideration both the interest of state and the interest of the investor. However, for arbitration, arbitration is unilateral because arbitration is based on consent. So arbitration is open only for the investor, even if in the new generation of investment treaties, there are some rules that protects the state, but until now, the state is not able, could not bring an arbitration action against the investor. Only the investor can initiate arbitration against the state, but the state cannot do that. The state can introduce counterclaims against the investor, but that supposes that there is already an investment arbitration that was initiated by the investor. So the person who decides if the dispute will be submitted to arbitration is finally the investors. Only the investors decide to accept the offer and to initiate the arbitration against the state. So let's see here what the UNCTAD said. They are good because they contribute to the a good investment climate, contribute to expanding economic and political cooperation between contracting parties, stability and predictability of the legal framework, good governance state, provide protection rights that are independent from the host state domestic legislation. And this is very important because if you provide right in the investment treaty, if you want to make modification, you need to renegotiate the treaty, and you need the consent of the other state that concludes the BIT. So it's a kind of international stabilization of the protection that is offered to the investor. However, if you provide the protection in your domestic law, it's very easy for the state to change its domestic law. So BITs, investment treaties, they provide a stabilization, international stabilization of the protection granted to the investment. Then, you know that customary international law, they improve customary international law and they clarify the international customary rules. They help to avoid politicization of investment dispute. Without BITs, without arbitration, if there is an investment dispute, sometimes the investor will involve its home states, and the dispute becomes a dispute between two states. But with the investment treaty, the investor can initiate arbitration, and this avoids any politicization of the dispute settlement. However, they have some argument against the investment treaties. They do not guarantee additional investment flow. The economists show that even if you have many bilateral investment treaties, that does not mean that we will attract a lot of investment. There is no relation between the conclusion of investment treaties and the movement and the attractivity of the investment. You can have 100 investment treaties, but we don't attract a lot of investment, because as I told you yesterday, in order to attract investment, you need rule of law, but you need other element, market, and if you have resources, their impact, the economic impact of the investment treaties is not demonstrated. The investment treaties might limit the rights of the state to change its regulations. The dispute settlement is considered as a mechanism that is, according to some people, dangerous for the state, because only the investor can use it, only provides for investor rights, no obligation, difficult to amend in case of changing of circumstances. So there is a debate. There is a debate on the bilateral investment treaties, on the arbitration, on the investment arbitration. And what are the options now for the state? What are the options? The options, some people said we have to avoid bilateral investment treaties. We don't need them, they are dangerous. There are many cases against the state. Some other people, they said, no, we have to remove arbitration from the investment treaties, and maybe it's better to establish a court like this court, the African Court on Human Rights. Some people, they propose the creation of a court for investment, open for the investors and open for the state. One of the options, and this option was followed by the European Union. The European Union today is promoting the creation of an investment court. Some people said we need an appeal. So you have a court with possibility to challenge the decision rendered by the court before an organ of appeal like the World Trade Organization. What was the option that was the solution that was adopted by the African? To understand or to conclude on the context, we can observe that when we follow the history of international investment agreement, we can find two periods. First period is the old generation of bilateral investment treaties and investment treaties till 2010. We have investment treaties that focus on the right of the investor, that did not take into consideration the right of the state. Then, since 2010, we have new generation of investment treaties that are considered more balanced. They take into consideration both the interest of the state and the interest of the investor. So let's see now what is the option, what is the solution that was followed by the African when they elaborated this African investment protocol. I think that the context is clear. There is a debate. There is a lot of discussion. Do we need investment treaty? Do you need to make them more balanced? Do you need arbitration? Then, in this context, in this global context, we have this protocol. And now we'll move to the second part of my presentation that is dedicated to this protocol. Some information related to the negotiation of the protocol, of the African Investment Protocol, how it was negotiated, how it was elaborated. We have today a method to elaborate, to negotiate investment treaties. This method is adopted by many countries, Europe, United States, Canada. This method is the following. We should involve all the actors, the businessman, the civil society, the citizen, because the impact of bilateral investment treaties is a global impact. So what we need when we negotiate an investment treaty is a transparency. Transparency and debate. That means, in a practical perspective, that when the state negotiates an investment treaties, the state has to publish the draft of the investment treaties and give all the actors the possibility to comment and to provide their opinion. This will make the investment treaties more acceptable. If you see how the European Union prepares its investment treaties, you see that we post the draft of the agreement. You involve the parties, all the parties, private parties, businessmen, civil society, NGOs, all of them, they are involved. This system, unfortunately, was not followed when they adopt the African Investment Protocol. It was a text that it very difficult to find. I am not sure that the draft was posted on the internet. There is no debate on this important text. We don't involve the African, all the African businessmen, civil society, citizen, they were not involved in the preparation in this text. They don't provide even their opinion. The text was elaborated behind the doors. I don't know who elaborates this text. Who are the experts that drafted this text? So the process of elaboration of the protocol was not, in my opinion, transparent. And we know today in investment there is a request, a demand of transparency. Transparency of arbitration. You see that many procedures are public. Unfortunately, regarding the protocol, this transparency was very, very limited. This is a little bit strange. Taking into consideration the context related to the investment treaties. Some people are for, some people are against. At least the citizen, the African, at least we cannot follow the opinion of the citizen, but at least you have to listen to them during the process of elaboration of the protocol. The approach of elaboration was not inclusive and was not transparent. We know this text when it is adopted. The text adopted now. It was adopted on 19 February 2023. 2 years ago, 3 years ago. More than 3 years ago, I think. 4 years ago now. It was described, considered as a text that reflects a common African position on various key areas related to investment. Common African of the states, or of the actors, or of the businessmen, or I don't know, common position of who? The states, maybe, the negotiator. The text is not, so is not into force because it requires 22 ratification to enter into force. You need ratification by 22 African states. And I am not aware of any ratification by any African state. I don't know what is the utility, what is the function until now. This text is not into force, and I am not sure that it will be into force in near future. 22, huh? It's not 2 or 3 or 5, it's 22. At least 40% of the African states. No country ratified this protocol. This is a little bit strange because it was described as a common view, common African view. So if it is a common African view, why there is no ratification by any state? Just the question. So you need 22 countries, then you have to wait 3 days, then the text enters into force. Okay. On the process, we finish. It's like between a draft and the treaty. is it soft? I don't know if this text will be applicable one day. Okay, let's now move to the protocol. Let's try together to understand this protocol, to see what are the rules, and if this protocol, is there any evolution or revolution adopted or followed by this protocol. We will follow the same structure. We will see the scope together. Then we will move to the protection, and we will see substantial protection and procedural protection. It will be impossible to study, to explore this protocol. How many pages, Luca, in the protocol? 30. I can't do it, but you will stay here till tomorrow. I will close the door, and we will start provision by provision. And you will see, in general, the style is not normative, it's narrative. When we draft rules, you need to be very precise. The protocol, unfortunately, is narrative. Do you agree with me? It's not a short provision, very long provision, and you have exception, and you have the exception of the exception. And the structure is not so clear. It's narrative. Let's understand the scope. And in order to understand the scope, let me start by a general remark. Then I will move to more technical issues to determine what is the scope exactly of this protocol. Remember, for the scope, you need 4 elements: investor, investment, territory, and time. In general, let's start in general. The protocol protects inter-African investment. Only inter-African investment. That means that the protocol protects the investment made by an investor from Ghana in Tunisia, an investor from Tunisia in Tanzania. The scope of the protocol is limited to inter-African investment. Don't forget that. That means that if the American or the French want to invest in Africa, the protocol is not applicable. The protocol is limited to inter-African investment, investment made by an investor from an African country in another investment country. Keep that in mind, because I will use that tomorrow to show you why this protocol has a very, very limited impact from a legal point of view and also from economic point of view. According to UNCTAD, African, they have some bilateral investment treaties between them. We have bilateral investment treaties between Egypt and Côte d'Ivoire, for example. We have 190 bilateral investment treaties between African countries. 130 are into force. But we have 770 extra African BATs. So African countries, they have treaties between them, but they have also treaties with other countries, with the United States, with China, with France. The impact of the protocol is only on the inter-African investment treaties. What the protocol said, the protocol requires that all the members in Article 49, they have to terminate their inter-African BITs because the protocol will be applicable. Not only they give them 5 years to terminate all inter-African investment treaties, BITs and multilateral investment treaties. So when the protocol enter into force, the states are supposed to terminate all inter-African investment treaties. Bilateral, regional, multilateral. But the protocol did not affect the investment treaties concluded between an African state and non-African states. The scope of the protocol is inter-African investment. We have to finish, we have to terminate when the protocol enters into force. We have 5 years to terminate all the inter-African investment treaties. Which is strange, because as I will tell you tomorrow that when this protocol enters into force, the non-African will be treated better than the African. Okay, that's for the general scope. Let's see now, from technical point of view, some provisions in this protocol. I told you yesterday that we have 2 pages of preamble. 2 pages. Then after the preamble, we have objectives of the protocol. Some comment on the objectives. We have a lot of objectives. Many, if you try to read them, any comment related to the objective that is mentioned in the preamble, but we have another article, Article 2, that deals with the objective. From a technical point of view, if you are a lawyer, the first question is why we did not put all the objectives in the same place. You can put them in the preamble or you can put them in an article. Why some objectives are provided in the preamble and the other objectives are provided under Article 2? Does it mean that the objectives in Article 2 has more value? Look at the objectives. All of them, correct me if I make a mistake, all of them are related to the state, to the protection of the interest of the state. There is no objective related to the protection of the investor. We have to understand that if you want to promote investment, you need to be balanced. We cannot move from a pro-investor model to a pro-state model. Investment requires that we take into consideration both the interest of the state and the interest of the investor. If you forget this rule, you cannot regulate correctly investment. It's normal if a state expropriates an investment without any reason, it's normal that the state compensates such investor. We have even if this rule in our domestic rules. So, in my opinion, the objectives needs to be more balanced. And this is not the case in the protocol. The objectives, all of them are related to development of state, protection of the state, security of the state, environment of the state, local community of the state. But there is no mention of the legitimate rights of the investor protected, no reference to the rule, to the function of the investment, because when we investor come to you, there are some positive impact. The investor will create jobs, will contribute to the economy. In my opinion, this preamble is not so balanced as indicated. Is it the view, the African view of investment? A view that focuses on only one part? It's like a marriage. You have to take into consideration the rights the position of the other party. If not, there is a divorce. Investment relationship requires that each party understand the position, the legitimate rights of the other. If not, we will not regulate it correctly. So, a pro-investor model is not good, a pro-state model is not good. We need a balanced model. That is my first comment regarding the preamble. Yes? Yeah. Yeah.
Investment prior to the state, the investors, and the public community. Doesn't that try to reflect from what you have been telling us? That
Give
there
me
is
an objective related to the investor.
Okay.
They mentioned that is balanced, then what we look, the objectives, you don't find the balanced approach that they mentioned.
Article
To be balanced is not enough to say that you are balanced. You have to show in the agreement that you are balanced. Yes.
I was reading is Article 2, which states
Yes, yes.
objectives, paragraph B.
Yeah.
It provides the objectives of this protocol are to establish a balanced, predictable, and transparent continental legal and institution framework for investment, taking account the interest of state parties, investors, and local communities. Now, saying that it is not balanced, there must be a provision that provides for that imbalances. Otherwise, we should presume there's balance between the investor and investments.
Okay, I understand. For me, we don't have enough, we don't have a lot of, they said that is balanced, but when you read, you see that the majority of objectives, the majority of consideration are related to the interest of the state. Even if they said that there is balanced, stable framework. Second, some objectives are very difficult to understand. Some consideration in the preamble are very difficult to understand. And I told you that you need the objectives, you need the preamble to interpret. So if you cannot interpret the preamble, we cannot understand the objective, how we can use the objectives to interpret? In my opinion, it's a narrative. It was better to focus on 5 or 6 objectives, balanced objectives, better than all these 2 pages with 3 pages of objectives. From practical point of view, it was better to indicate clearly some objectives, taking into consideration the interest of the state and the interest of the investor. Let's see now who is the investor under the protocol. The protocol provides for a definition of the protected investor. According to the protocol, or as I told you, the investment treaties set out 2 kinds of investors. We have physical person, like me, like you, like Luca, physical person. If Luca invests here, he's investor. And we have legal person, corporation, companies. So you find both categories, physical or natural persons and legal or corporation. They are protected, they are considered as protected investors. To determine the natural persons, in investment treaties, we have 2 elements. The majority of treaties refer to nationality. So if you are a national of one country and you invest in another country, you are protected. treaties, they add residence. For example, bilateral investment treaties concluded by Canada protect not only Canadians that invest in the other country, but also Canadian residents. Canada-Cameroon bilateral investment treaties provide that Canadians, when they invest in Cameroon, they are protected. But also, even if non-Canadians that are resident in Canada and they invest in Cameroon, they are protected. So we have two elements to determine who is the protected investor: nationality and residence. Regarding legal person, corporations, in investment treaty practice, we have three elements. We have the incorporation. If the company is incorporated in one country and invests in another country, the company is protected. We have the seat of business, the location of the company seat, and we have the control, the three criteria that we find in investment treaties. Let's see the African Investment Protocol, how the African Investment Protocol determine the protected investors. According to the African Protocol, we have two kinds of investors. We have the natural persons and we have the legal person. Natural person. Who is the natural person? Is the national of a state party in accordance with its law and regulation, who made an investment in another country. Okay? If you are from Ghana and you invest in Morocco, you are protected if you are Ghanaian citizen. That's the protocol, what he said. Then he said, a natural person who holds dual nationality shall be deemed to be exclusively a national of the country of her or his effective nationality, or where he ordinarily or permanently resides. What does it mean? That means that if you have a dual national, for example, someone from Tanzania and from Tunisia, if he invests in Tanzania, he's not protected if his effective nationality is Tanzanian or if he resides in Tanzania. Many investment treaties, they exclude dual national from the protection. We find this in many treaties. I give you my position. Why do you exclude them? Why, if they bring money to the country, if they create job, if they contribute to the development, why do you exclude them from the protection? What's the problem? What is your problem with the dual nationals? So if a Moroccan investor come here in Tanzania, he's protected. And if he has also the nationality of Tanzania and he's Moroccan also, and he want to invest, you have to see which is his effective nationality. What is important is the contribution of the investment, the quality of the investment. This approach, mechanical approach, taking into consideration some legal links, could not be justified from economic point of view. What is important for the protection of the investment is not what is the nationality of the investor, if it is a French or American or Tunisian. What is important is the contribution. If he will create jobs, if he will bring you new technology, this is the approach that we should follow. And not a mechanical approach focusing on legal links without any analysis of the impact of the quality of the investment. And the protocol provides that one of its objectives is to promote the economic development and the sustainable development. If you have a binational investor that promote the sustainable development, that create a good investment, why do you exclude it? and you protect another investor because he has the nationality of a country that is protected, you have to think about this. This is a very traditional approach, disconnected from the economic realities. What we need here in Africa is an investment of quality, not an investment which nationality is determined by a legal, neutral element. First comment. Then they said investors covers also legal or judicial person. The term judicial person is not clear. I did not understand what is judicial person. Legally understand. Judicial person. I don't know who writes this. What's the difference between legal and judicial? Because everything is legal. Everything is based on law. In French, they said, personne morale ou juridique. I did not understand. Personne morale for me is juridique, it's the same. Why we make a distinction between personne morale and personne juridique? If you put it, that means we have two categories. So please, could you tell me or explain to me what is the difference between morale and juridique? The morale is juridique. In English, the same. They said legal or juridical person. Juridical person. Juridical is legal. Is there any difference? Do you have this distinction in your system, legal system? I don't recognize that. So this need a review. Who drafted this? Why it was drafted without giving to the all involved parties a possibility at least to comment? In European countries, when they reform the ICSID rules, they publish the drafts on the ICSID website and they open the door for every party, professors, students, social NGOs to comment. And this ameliorates the quality of the text. This was not followed. Okay. We understand that the African Investment Protocol covers physical person and legal person. Who are the legal person? Legal person are created legal or juridical person, the state party of incorporation or registration. What is the difference between incorporation and registration? It's the same. Registration is incorporation. If you are incorporated in a country, that means that we are registered in the country. Okay, let's move. The state party of incorporation or registration of the investor in accordance with the laws and regulation of that state party, and where that legal or juridical person maintains its statutory seat together with substantial business. Then we have B1B, a legal person, in accordance with the definition of the legal. You see this, it's not so easy to follow. In accordance with the definition of the legal or juridical person of the home state in this article that has made an investment in the territory of the host state. It's not so clear. In French, maybe I have to understand. Une personne morale ou juridique, conformément à la définition de la personne morale ou juridique. This is not good. Hein? Une personne morale ou juridique, conformément à la définition de la personne morale ou juridique de l'État d'origine donnée dans le présent article qui a effectué un investissement sur le territoire de l'État hôte. Après, then we find B, une personne morale. Okay, let me see what I understand. That means that if you want to be protected and you are a legal person, you need to be created, incorporated in one country, and you need to have substantial activity in this country in order to be protected in the other country. That means that if a company is incorporated, only incorporated in Tanzania, and this company will invest in Kenya, is not protected. Because there are two requirements. You need to have an incorporation in one country, then you need to have a substantial economic activity in the country of incorporation. If a company that is only incorporated bring you a big investment, creates a lot of job, why do you exclude it? Okay. You need incorporation, then substantial activity in the home country. In the home country, to be considered as protected investor, if you are a legal or juridical person. As I told you, the protocol requires substantial business activity in addition to the information for the company of the home state. Then we have 3 paragraphs to understand what is substantial activity. Very difficult to understand. Substantial business activity requires it's very, very long. It needs a substantial effort, a substantial energy to understand what is substantial. And finally, I understand that it's case by case definition, and it's for the arbitral tribunal to decide. Wait. Sorry, I am a little bit lost, because you understand that it's okay, this is substantial business activity in French and in English. Examination of circumstances on a case-by-case basis by a state party of that circumstances, including many reasons. It's not too clear. Narrative, not normative. Norms must be clear, short, very well drafted. It needs review. Not only one review, but many reviews. Okay, now let's move to another notion. That's the notion of investment. Very important notion, the notion of investment. And here, most bilateral investment treaties, they provide for a general definition. As an example, we have here treaty concluded by Netherlands, and as you see, investment means every kind of asset. Every kind of asset is considered as investment, protected investment. Then we have a list as illustration of some kind of investment in which we find movable, immovable property, shares in company, claims to money, intellectual property rights, business concession, and contract, including concessions and contract related to the natural resources. All of them are considered as protected investment. As you see, this notion is extensive. Everything is considered as an investment. However, some treaties provides for another definition. You look here, the term investment, any asset, but in accordance with the laws and regulation of the country, of the host country. So in order to be protected, asset is not enough. You need to invest this asset in accordance with the rules of the host country. So you have here another element, additional element that is required in order to be a protected investment, in order to have a protected investment. This is your investment, your asset must be invested in accordance with the laws of the host state. We have a third approach, that's the new approach, enterprise-based approach. So investment is not an asset, is an enterprise. You need to have an enterprise to have an investment. And the African Protocol says that investment means an enterprise or company. So it's not an asset definition approach. It's corporation enterprise approach. So the investment under the protocol is a company. You need to have a company to be protected. That means that the natural person or the legal person that is protected must have a corporation or an enterprise in the host country, and this corporation or this enterprise is the investment. Then the enterprise or company might possess assets such as, then we have the list of all assets that the enterprise can possess. Let me make some comment on the definition of investment before moving to other articles, other provisions. This is a corporation or enterprise definition. The protocol requires also conformity to the host state. Then the protocol said that in order to be protected, the investment must have some characters like significant contribution to the host state sustainable development. What is the significant? How we can measure it? Significant, not significant. It's very difficult to interpret such notions. Then they exclude debt, securities, portfolio investment. Do you remember of portfolio investment? Yesterday I told you that there is a distinction between financial investment and foreign direct investment. So they exclude if you have less than 10%, you don't have a protected investment. Then we have a denial of benefit clause. The state can exclude the protection of some investor or some investment in the event of the investment has no substantial business activity in the territory of the home state. It's not the investment, it's the investor has no substantial activity because the investment cannot be in the home state. The investment is in the host state. So here there is something that is strange. We can exclude the protection if the investment has no substantial business activity in the territory of the home state. But the investment is made not in the home state. The investment is made in the host state. So what is this? Look, they said that state party at any time deny an investor of another state party and the investment of each investor the benefit of the protocol. So the state can exclude the investor or the investors or the investment from the protection. Then they give you a list. And if you look to E, if the investment has no substantial business activity in the territory of the home state, the investment is made where? Not in the home state, in the host state. So how to exclude the protection if the investment has no substantial activity in the home state? And it's the host state that excludes. Look in French. L'État parti peut à tout moment refuser à un investisseur d'un autre État parti et à l'investissement de cet investisseur les avantages du traité si un investissement n'a pas d'activité économique substantielle sur le territoire de l'État d'origine. Where the investment is made. In the host state, not in the home state. Yeah. But the investor, yeah, here they speak, they mention the investment. If they put investor, it will be okay. You understand? If a company from Tanzania that has no substantial activity in Tanzania and the company makes an investment in Kenya, Kenya can exclude this investor because this investor has no substantial link with the home country. But you don't need that. Why? Because when you look at the definition of investment, you see that in order to be protected, you need to be incorporated and substantial business in the home state. Yes. So why you need that? Because in order to be protected as investor, you need to be incorporated in your home state, and you need substantial economic activity in this home state. So even if you remove investment and you put investor, we don't need that, because already to be a protected investor, you need to have an incorporation in the state and substantial business activity in this state. If not, you are not investor, you are not protected. So how you give the state the possibility to exclude a protection because the investor has no substantial activity in the home state. If he has not a substantial activity in the home state, he is not protected. You see? So there are some rules to examine carefully. So I cannot understand if they mention the investment here, the investment is not made in the home state. The investment is made in the host state. And if they want to mention the investor, we don't need that, because if he has no substantial activity in the home state, he is not protected. We cannot imagine how if he has no substantial activity in the home state, he's not protected. So if he's not protected, there is no need for the host state to use this denial of benefit clause to exclude him, because he's already excluded. Sometimes it's technical, I am so sorry, but as you see, there are some rules, some provisions that raise some discussion. Okay, we finish the scope. We move to the protection. The protocol is like an African vision, balanced African vision, and we will try to see if this vision is balanced as provided. Just the discussion can be very long, but just I want to show you one provision. We will try to, you know that many investment treaties provide for fair and equitable treatment. And fair and equitable treatment is very difficult to interpret. There is a long debate regarding the interpretation of fair and equitable treatment. The African protocol, they decided to remove the fair and equitable treatment and to put another rules. They said treatment, administrative and judicial treatment. Administrative and judicial treatment. Okay, let's see that. Each state party shall ensure that, until now it's okay, ensure that in administrative and judicial matters, investors and investment of another state party are not subject to treatment which constitute, until now is okay. Then, which constitute what? A fundamental denial of justice. So denial of justice is not enough. You need to prove a fundamental denial of justice. What is fundamental denial of justice? How to make a distinction between the denial of justice that is fundamental and the denial of justice that is not fundamental? Who can give me an example of fundamental denial of justice? The word denial of justice is very far. So, in order to make the state responsible, the investor has to demonstrate not only denial of justice, fundamental denial of justice. What is fundamental denial of justice? So denial of justice is not enough. The denial of justice must be fundamental. Then, look, in criminal, civil, and administrative adjudicative proceedings, an evident denial of due process, evident. What is the evident denial of due process? Evident. So denial of due process is not enough. You need to demonstrate that the denial of due process is evident. Then you continue. As manifest arbitrariness, manifest arbitrariness, manifest. Arbitrariness is a lot. You have to show manifest arbitrariness. You have, I don't know. So the requirement, I don't know if this text could be applicable. Because if this, if you then discrimination based on gender, race, religious belief, or abusive treatment in administrative and judicial proceedings. I understand if there is only a denial of justice and denial of due process and arbitrariness that are not, how do they say, that is not fundamental, that are not evident, that are not manifest, it's okay. No violation of the rule. Just an example to illustrate how the protocol provides the substantial protection. Regarding dispute settlement, the protocol did not provide any dispute settlement mechanism. They said, we will see next round what is the dispute settlement mechanism. That means that if this protocol enters into force, all the arbitration mechanism provided in the African bilateral investment treaties, there will be replaced by nothing. With provision like this, it is important for, in my view, to have a dispute settlement mechanism that is open, because we want to know what is the meaning of due process, evident due process, or manifest, I don't know what. So it's very difficult to interpret, to understand. The protocol did not provide for arbitration between the investor and the state. And the protocol provides that disputes related to investment must be submitted to the interstate mechanism under the state-to-state mechanism dispute settlement related to AfCFTA. The dispute settlement will be negotiated in a next coming round. Normally 1 year. But until now, we don't have any dispute settlement mechanism. Let me finish. I find a little bit strange that in international law, in investment law, dispute settlement mechanisms are very important. I think that if you want to provide a system that is balanced, you cannot disconnect the substance to the dispute settlement mechanism. They are interrelated. I don't see any reason why they disconnect them. And here, with provision like this, the existence of a dispute settlement mechanism is very important to understand, to interpret. If not, it will be very difficult to make this protocol applicable. This brings me to the end of today's sessions. I will tomorrow show you that the impact of this protocol, both from legal and economic point of view, is very limited. And all this debate is limited, the interest of the debate. And the interest, to be honest with you, is very lot of debate for nothing. the final product that we have, unfortunately, needs further elaboration, further amelioration. So I'm sorry to tell you that I am a professor. I am supposed to explain to you an objective point of view. I am not a negotiator of this agreement. And my position is, as I mentioned, there are many issues that needs to be reviewed because we are negotiating in 2020. We have the case law, we have the practice, the European investment law practice, the American practice. And if you see the product that is proposed, it did not answer, it did not take into consideration the expectation of the African businessmen, of the African civil society, of the African investors. And it will raise also many problems. Thank you very much. We will continue our debate tomorrow. I'm very sorry sometimes I'm direct, but you have to say things directly. We don't need to say them diplomatically. It's good or not good. I am not here negotiator. I am not doing politics. I am professor of law. I need to explain to you the situation objectively. And unfortunately, the text, as it is drafted, is not a text that is very clear, well drafted, well structured, and you will see tomorrow what is the impact of this investment protocol. Thank you so much. See you tomorrow.
Don't you want to have questions? So 1 or 2 questions? Short ones.
Yes, short, very short. Comment and questions.
You mentioned that there is no dispute resolution mechanism for an investor under the protocol. I would like you to help explain Article 46 read together with Article 45.
Yes, it's a state-to-state
No.
dispute settlement.
45 is on dispute prevention and grievance management, where these investors can go through their host states and address their complaints. Then Article 46 relates to where a dispute is between an investor and a state party.
Yeah, there we don't have arbitration. We don't have arbitration. We don't have any binding mechanism. So the investor tries to settle his dispute amicably with the state. If there is no solution, there is nothing to do. He has to contact its state, and it's for its state to initiate a dispute settlement mechanism against the other state. So it's like diplomatic protection. This is the mechanism that was used 50 years ago that is provided under the protocol. So we don't have arbitration, we don't have a direct dispute settlement mechanism that is open to the investor against the state. And even if we don't have a dispute settlement mechanism that is open for the state against the investor, because the protocol provides for obligation now that the investor has to observe. So the existence of a dispute settlement could be even used by the state against the investor. We don't have that. What we can use is the state-to-state dispute mechanism under the AfCFTA Protocol on dispute settlement, but you need to convince your state in order to initiate, and if you want to know my position on the protocol on dispute settlement, you have my video presentation in French and in English, there are also a lot of problems regarding the dispute settlement mechanism under the AfTA. And the protocol also provides some rules that are not so clear. So even if you use the state-to-state mechanism under the protocol, the AfTA protocol on dispute settlement mechanism, there are some problems. You have 2 hours, my presentation here in Arusha in French and in English, and I recommend you it's on YouTube, in the website of the Institute, and you see also my critics and the problems that the protocol rise. But we don't have the arbitration mechanism to settle dispute between state and investment. We don't have even if a conciliation mechanism, ADR mechanism in the protocol, but they say that they will elaborate that next time. You know, here, in order to elaborate rules, you need a lot of steps. Steps 1, steps 2, step 3, then we arrive at step 4, and in step 4 you said, no, what we did is not good, so you have to go back. This strategy of steps is not good, so you elaborate a full text, good text, or not. Round by round, step by step. The most important issue, they don't deal with it. And they said that they have 1 year to negotiate a dispute settlement. Now we are 4 years. It was adopted on 2023. And if you cannot do it in 1 year, why you put 1 year? Put it open. It's better. Next, the states will negotiate a dispute settlement in another treaty. 1 year. Don't put deadlines that you are sure that you cannot observe. That makes your text less serious. Or put 10 years, or 20 years maybe. We'll arrive. Next generation. Yes, why not? Another comment, another question? So if you have a question, you can ask me tomorrow your question. Sorry to be direct. I am not here to, I'm not an artist to show you the beauty of the legal rules. I am here to explore, to try to understand, to think the practical impact, the problem of some negotiators that are not involved in the practice. They are disconnected to the practice. They don't know the case law. If there is 2 versions, they put them together and they move. They mix. Then when you mix, it's very difficult to find the meaning. I suppose that someone wants to put legal person and another judicial. So they put them together and they move. It's not a good method when we draft legal text. We need clear, structured. That's what some people call the constrictive ambiguity. Constrictive ambiguity. And this concept, I know it because last time there was some negotiator of some African instrument. It was very difficult to understand the meaning of the provision, and one of the negotiators told me, this is the constrictive ambiguity. Yeah, why not? So there is an ambiguity that is constrictive and ambiguity that is not constrictive. When the ambiguity is constrictive and when is not. Thank you so much.
Ladies and gentlemen, thank you very much, Walid.
Before we take the short break to get ready for the last session for the day, I have a short announcement. Our friends from Uganda are leaving tomorrow morning. Sadly, they will not be able to be with us for tomorrow's sessions and more especially for tomorrow's great event. They will miss the great event. There is a great event tomorrow. Now, they would like to say a few words before we say bye to them. And my dear sister and brothers from Uganda, it has been a wonderful moment for us to be with you. Now, if you want to tell us something, you have the floor.
Okay. Good evening. I guess it's or good afternoon. I'll begin with introducing myself. My name is Charity Fiona Ninsima. I am from Uganda. I am a Foreign Service Officer, a lawyer by profession. I work with the Ministry of Foreign Affairs, Uganda. I am very happy to have met everyone here. I do not know if at this point I should let my colleagues introduce themselves.
Good evening, good afternoon, colleagues. My name is Sewa Garagamal Abdul Nasser. I'm also a Foreign Service Officer with the Ministry of Foreign Affairs, a lawyer as well. And it has been a very interesting and educative time that I've spent at the Academy. And I hope we're able to utilize the knowledge we have all acquired here today, or within these 2 weeks, to enable us prosper in our different fields and careers. Thank you very much.
Good afternoon. My name is Marvin Nyanzi Sentam Kayanja from the Ministry of Foreign Affairs. Though I'm not a lawyer, but the Academy's some of the sessions were touching into my research for my master's. So it was very insightful to join you for the last 2 weeks. And yeah, we hope to connect more when you visit our countries and when we visit some of your countries. Thank you.
We are so sad to be leaving, Professor. It has been a really enriching 2 weeks period. We have had, on the practical side, I would like to say maybe to confess that I envy the students that are here because I did not get the chance. It's been like 2 years back, but I'm glad that I come here to study with you and maybe apply the aspects in the practical world. It is also okay whichever time you get to get the knowledge and maybe you get to understand better the various aspects of the legislations, especially the African legislation. It has been enriching. We are so grateful, but we are still very sad to leave, and we had something small for you. I hope you appreciate it. It's from Uganda. Uganda is a coffee-producing country. Please find time and visit. And Professor, we would be really grateful if you came and showed the people what we would like to talk about Uganda. And yeah, so Marvin will help us. So inside the box, Professor will find the different kinds of coffee. This is one of the coffee producing companies in Uganda called Nonda Coffee. When you visit Uganda, when you pick an interest, you will find very many companies that produce different kinds. And I believe it will be a delicacy for you as well. There is a coffee mug. Professor, you can show them as well. It's yeah. Yes. Thank you so much, Professor, for helping us actually complete our registration process. It was tedious, you might recall, but we ended up here, and we are really grateful. Thank you so much, sir.
But there is more, and you didn't say that there is a secret. So thank you very much. I can see more than you indicated, which means, yeah, that's what I wanted to say actually. This is a special coffee. The smell at the end, so that you know what I'm talking about. Before that, I would like to. It's fortunate, as I say, that you will not be with us tomorrow for the great farewell. Now, since you are leaving in the morning, I would like to give you what we had planned to give you tomorrow. And those are your certificates. And for this to happen, I would like to call you to take your seats so that we do things quickly before we start the next session. Can you come here, please? And at the same time, I will, thank you very much. I will request Professor Ben Hamida to join me here so that Eric will be calling them one after the other for them to receive their certificates. And I would request the cameraman to be ready to immortalize this event. Eric?
Thank you, Prof. The first one is Sebagala Gamal Abdul Nasser.
Face the cameraman.
The second one is Marvin Sentamu Kayanya Nyanzi. And the last one we have Charity Fiona Ninsima.
Thank you. Thank you very much. Thank you, Prof. Ben Hamida. We will keep in touch, and very soon I will send you an update on future activities of the Institute and upcoming events, and I will request you to link us to relevant participants to those, and don't get tired of me. I will be bombing you with emails and WhatsApp messages, and in the meantime, I wish you all the best and safe travels back home, and best regards to everybody. But we are still together, of course. Thank you.
Yes, Professor has said not any corruption, so everything in the big box is to him. And we have some other small packages in here that he will see how to distribute to the best of their ability. And we hope that everybody is able to take a piece of something. If you're not able to, when you come to Uganda, we hope those who will not be able to get, because we didn't know the number, we hope when you come to Uganda, we'll be able to gift you what you didn't get today. Thank you.
Maybe the next session of Kilimanjaro should be held in Kampala. And everybody should be present. Yeah? We'll talk about it. This will be distributed at the end of the last session, I think, so that everybody takes something home. Yeah? Now, Eric, what do we do now? What's the time? What's the time now? We still have 3 minutes? Good. The interpretation, the application of human rights instruments, and who have accepted that this academy is held here. The court will be represented by my brother Raymond, that I would like you to join your hands to welcome. He will be talking about the philosophy behind the establishment of the court, its achievements, its challenges, and perhaps some prospects for the future, and a few other details that he will share with us. Then we will open the floor to whatever question that you may have. He is ready to provide any clarification you are looking for. Raymond, you are most welcome.
Good afternoon, everyone. I'm sure that no one has spoken French since this morning. I want to give to interpreters a bit of work because I will have to express myself in French. Merci, je suis Raymond Diouf, je suis juriste principal en chef. Okay, let me give you a few seconds. Je suis Raymond Diouf, je suis juriste principal en chef, chef de l'unité des affaires judiciaires. Et je m'en vais vous faire une brève présentation de la Cour. On m'a dit tout à l'heure qu'il y avait déjà eu une première présentation. Celle-ci va être beaucoup plus courte. Elle va concerner essentiellement certains aspects spécifiques qui sont relatifs it okay? C'est bon? Il faut que je parle, hein? Il faut que je parle pour qu'on voit si... Est-ce que ça marche? C'est bon? That's fine? Thank you. Cette présentation, disais-je tout à l'heure, elle va être beaucoup plus courte et va se focaliser sur certains aspects. Nous parlerons au niveau de l'introduction de la création de la Cour, de la complémentarité avec la Commission et du rôle de la Cour, notamment sa place dans l'architecture de protection des droits de l'homme et également en relation avec l'agenda 2063. Ensuite, nous aurons certains aspects sur la compétence de la Cour, notamment l'évolution de la compétence, notamment matérielle et territoriale. Et enfin, je vous parlerai des quelques jurisprudences portant sur les droits subjectifs, des droits civils politiques, des droits économiques, sociaux et culturels. En conclusion, il s'agira de parler des défis de la Cour et de l'avenir de la Cour. Alors, vous le savez déjà, la Cour elle a été créée par le protocole dit de Ouagadougou qui a été adopté en 1998, lequel protocole est entré en vigueur en 2004. Cette Cour elle est née de la nécessité d'avoir un organe juridictionnel, puisque, comme vous le savez certainement, la Commission rend des recommandations et ces recommandations n'ont pas de caractère obligatoire. La Cour n'est pas née ex nihilo donc, et avec la Commission, elle entretient une relation de complémentarité. Lorsque je dis Commission, je fais référence à la Commission africaine des droits de l'homme et des peuples. Faisons bien la distinction entre cette commission et la commission de l'Union africaine qui est à Addis Abeba. Cette commission dont je parle, elle est à Banjul. Il s'agit donc de la Commission africaine des droits de l'homme et des peuples, avec laquelle la Cour entretient une relation de complémentarité. Cette complémentarité, elle est fondée sur l'article 2 du protocole, mais également sur certaines dispositions. Vous pouvez faire défiler les slides, s'il vous plaît. Également sur certaines dispositions du règlement intérieur. Et en vertu de cette complémentarité, en vertu de cette complémentarité, la Commission a eu à saisir la Cour de certaines affaires. Vous avez certainement entendu parler de l'affaire OGIEC, Commission africaine des droits de l'homme contre le Kenya. La Commission a également saisi la Cour d'une autre affaire contre la Libye. En vertu également de cette complémentarité, il y a eu des retraites conjointes entre la Cour et la Commission. La première a eu lieu à Addis Abeba en octobre 2022, à l'issue de laquelle cette retraite, une feuille de route a été adoptée. La deuxième retraite conjointe a eu lieu ici à Arusha au mois de juin 2025. Et à l'issue de cette retraite, des lignes directrices ont été adoptées. Ces lignes directrices concernaient le renvoi d'affaires entre la Cour et la Commission, disons la saisine de la Cour par la Commission. En ce qui concerne la place de la Cour dans le système régional africain, la Cour est le seul organe juridictionnel, mais elle coexiste avec deux autres organes quasi-juridictionnels, l'un ayant une vocation, ayant une portée générale, c'est la Commission, et l'autre ayant une vocation spécifique sur les droits et le bien-être de l'enfant. Alors, maintenant, il faut voir quel rôle joue la Cour en relation avec l'agenda 2063. L'agenda 2063, c'est un fonctionnement où on va passer rapidement. La Cour est composée de 11 juges qui sont élus pour un mandat de 6 ans. Et dans l'élection, il est pris en compte le facteur d'équité dans la répartition géographique et dans le genre. Il y a 5 régions en Afrique. Chaque région a droit à un juge de sexe masculin et un juge de sexe féminin, ce qui fait 10 juges, plus un 11e juge qui occupe ce qu'on appelle un siège flottant. Il y a évidemment des garanties d'indépendance et d'impartialité. Parmi ces garanties, il y a également les immunités dont les juges bénéficient, mais également il y a des incompatibilités d'exercice de certaines fonctions ou de certaines charges qui peuvent remettre en cause l'indépendance ou l'impartialité des juges. Lorsque les juges sont élus, ils élisent eux-mêmes un président et un vice-président pour un mandat de 2 ans renouvelable une fois. Là également, il y a l'équité dans le genre et également dans la répartition géographique. Actuellement, le président est un homme de l'Afrique centrale et la vice-présidente est une femme originaire de l'Afrique du Nord. Dans leur travail, les juges sont assistés du greffe, dirigé par le greffier de la Cour, assisté lui-même du greffier adjoint et également d'autres fonctionnaires du greffe. Nous avons essentiellement 2 divisions au sein de cette Cour. Nous avons la division de l'administration et des finances et nous avons également, d'un autre côté, la division juridique dont moi-même je fais partie. Alors, le fonctionnement de la Cour, comme vous le savez, elle siège par session. Il y a 4 sessions par an, l'une en mars, puis en juin, en septembre et puis en novembre. Mais il peut arriver qu'il y ait des sessions extraordinaires convoquées par le président ou bien sur la demande de la majorité des juges. Qu'en est-il maintenant des réalisations? Ces réalisations, nous allons les aborder sous l'angle de la jurisprudence de la Cour. Cette jurisprudence porte sur plusieurs points, plusieurs aspects que nous avons décidé de choisir pour montrer quelles sont les réalisations de la Cour. D'abord, sur la question de la compétence. La compétence de la Cour, elle est prévue par l'article 3 du protocole, en vertu duquel la Cour peut connaître de toutes les affaires et de tous les différends dont elle est saisie concernant l'interprétation et l'application de la charte, du protocole et de tout autre instrument. Il s'agit là de la compétence matérielle et la Cour a eu dans sa jurisprudence à expliquer ce qu'était un instrument de droit de l'homme. Il y a des arrêts, par exemple l'arrêt APDH contre Côte d'Ivoire. C'est un arrêt dans lequel la Cour a expliqué ce qu'était un instrument de droit de l'homme. Pour la Cour, donc, un instrument de droit de l'homme s'apprécie par rapport à son objet et à son but, en ce qu'il prévoit cet instrument, soit des droits subjectifs au profit des individus, soit des obligations à la charge des États, lesquelles obligations ont pour corollaire des droits subjectifs des individus. Cette jurisprudence a été reprise dans d'autres affaires, par exemple l'affaire Oumar Mariko ou encore l'affaire RDC contre Rwanda, où il s'est agi de déterminer si oui ou non le pacte des Grands Lacs était un instrument de protection des droits de l'homme. Il y a également eu une autre évolution, cette fois-ci sous l'aspect de la compétence territoriale. Classiquement, la Cour a toujours considéré que la compétence territoriale était établie lorsque les faits se déroulaient sur le territoire de l'État défendeur. Mais dans 2 affaires, la Cour a eu à aller plus loin, à procéder, si l'on peut appeler ainsi, à une extension de la compétence territoriale. La première de ces affaires, c'est l'affaire Bernard Morna, dans laquelle la Cour a estimé que compte tenu de la nature de certains droits allégués ou de certaines obligations, on ne pouvait pas se limiter aux critères classiques de la compétence territoriale. Donc, dans cette affaire, il s'était agi, entre autres, de se prononcer sur l'allégation de violation du droit à l'autodétermination d'un peuple. Et la Cour a estimé que dans cette affaire, il fallait, compte tenu de la nature du droit, il ne fallait pas se limiter aux critères classiques, à savoir le territoire. Dans une autre affaire, République démocratique du Congo contre Rwanda, la Cour a également estimé que compte tenu de la nature de l'affaire, qui mettait en cause deux États, et il y avait au cœur de cela un conflit armé, elle ne pouvait pas considérer le critère classique. Elle devait suivre, pour ainsi dire, la juridiction de l'État. Or, la juridiction de l'État peut être exercée en dehors de son territoire. Elle a mis en avant l'extraterritorialité pour retenir sa compétence dans cette affaire. Pour ainsi dire, la Cour se départit maintenant de plus en plus de l'approche classique, consistant à dire qu'elle a compétence lorsque les faits se déroulent sur le territoire de l'État défendeur. Qu'en est-il maintenant des droits substantiels? J'ai fait un choix entre plusieurs droits, mais il y a ici par exemple le droit à la vie sur lequel la Cour s'est prononcée, y compris en rendant des ordonnances de mesures provisoires. Dans plusieurs affaires, notamment contre la Tanzanie, la Cour a eu à demander à l'État défendeur de s'abstenir de tout acte qui pouvait entraîner la perte en vies humaines. Ça, c'est une affaire contre la Libye, mais elle a également eu à demander à certains États de surseoir à l'exécution de la peine de mort à laquelle le requérant avait été condamné. En droite ligne avec cette peine de mort, la Cour a estimé que le caractère obligatoire de la peine de mort constituait une violation du droit à la vie. Par caractère obligatoire de la peine de mort, il faut entendre le fait que le juge ne puisse pas avoir de marge de manœuvre, qu'il ne puisse pas choisir dans la fourchette de la peine une peine autre que la peine de mort. En relation toujours avec la peine de mort, le mode d'exécution de la peine de mort est également pris en compte. C'est pourquoi la Cour, dans une de ses affaires, a estimé également que la pendaison comme mode d'exécution de la peine de mort était par nature dégradante. Outre la question de la peine de mort, le droit à la vie protégé par l'article 4, la Cour s'est prononcée à plusieurs reprises sur l'article 7 de la Charte qui protège le droit à un procès équitable. À travers le droit à un procès équitable, la Cour s'est prononcée sur le droit à la défense, y compris le droit à l'assistance judiciaire, le droit également à être jugé par un tribunal indépendant et impartial fait partie intégrante du droit à un procès équitable. Vous voyez là les références jurisprudentielles. La liberté d'expression a été également un droit sur lequel la Cour s'est prononcée, notamment dans l'affaire Loé Issa Konaté contre le Burkina Faso. Outre ces droits qu'on peut qualifier de civils, la Cour s'est également prononcée sur des droits politiques, comme le droit de participer librement à la direction des affaires publiques, ou l'obligation pour chaque État de mettre en place des commissions électorales indépendantes. Et dans le cadre également des droits électoraux, la Cour a estimé que l'interdiction des candidatures indépendantes était contraire à la Charte, notamment à l'article 11 et à l'article 13. De même, L'interdiction d'alliances électorales est également contraire à la charte, comme la Cour l'a décidé dans l'affaire Sébastien Ajavon contre Bénin. Outre ces droits civils et politiques, la Cour s'est également prononcée sur les droits économiques, sociaux et culturels. La justiciabilité de ces droits, vous le savez, fait l'objet de beaucoup de discussions. Et dans plusieurs affaires, la Cour s'est prononcée sur ces droits, notamment l'affaire Commission africaine des droits de l'homme contre le Kenya, le droit à la terre d'un peuple autochtone, le droit à l'identité culturelle, la protection qui est due aux communautés autochtones. Et dans cette affaire, la Cour a eu une approche collective de ces droits. Le droit à la santé est également un autre droit sur lequel la Cour s'est prononcée dans une affaire contre la République de Côte d'Ivoire. Et dans cette affaire, la Cour a clarifié que le droit à la santé supposait l'existence d'éléments essentiels et indépendants. Ces éléments sont les suivants. Il s'agit de la disponibilité du droit, de l'accessibilité de ce droit, de l'acceptabilité et évidemment de la qualité de ce droit. Dernier droit sur lequel je vais me pencher, le droit à l'environnement. Également, dans une des affaires dont j'ai parlé tout à l'heure, l'affaire Lido, contre la République de Côte d'Ivoire, la Cour a estimé que le droit à un environnement inclut, entre autres, la prévention et la réduction de l'exposition de la population à des substances nocives. Cet arrêt, il faut le dire, renforce la protection environnementale en Afrique. Elle consolide la jurisprudence de la Commission africaine dans l'affaire Sérac contre Nigeria. Parlant de l'environnement, on peut glisser vers les changements climatiques. La Cour a également une affaire, une demande d'avis consultatif qui est relative aux obligations des États en ce qui concerne les changements climatiques. Mais il n'y a pas encore de décision. Cette affaire est pendante. Il ne fait pas de doute qu'il s'agira d'une première en Afrique. Alors, venons-en maintenant aux défis. Venons-en aux défis auxquels est confrontée la Cour. Le premier défi, c'est celui des faibles ratifications. Le protocole, à ce jour, est ratifié par 34 États sur la totalité des États membres de l'Union africaine, tandis que la déclaration, c'est-à-dire la faculté pour un État de laisser ses citoyens, ou en tout cas ceux qui vivent sur son territoire, de saisir la Cour, ces déclarations, aujourd'hui, sont au nombre de 7. Elles étaient 12. On a fait face à 5 retraits, celui du Rwanda en 2016, celui de la Tanzanie en 2019, celui du Bénin en 2020, celui de la Côte d'Ivoire la même année, et dernièrement, le retrait de la Tunisie en 2025. Alors, ces retraits créent évidemment une difficulté puisqu'ils restreignent l'accès à la Cour. Lorsqu'un État retire sa déclaration, les personnes physiques ou les ONG qui ont le statut d'observateur devant la commission de Banjul ne peuvent plus saisir la Cour. Mais il est possible que la commission, étant saisie par une personne physique, vienne saisir la Cour d'une requête. L'autre difficulté à laquelle nous faisons face, c'est l'inexécution des décisions de la Cour. Nous avons un taux d'exécution assez faible, 3% dirait-on, sur tout le nombre des affaires. L'exécution, comme vous le savez certainement, relève du ressort des organes politiques, notamment le Conseil exécutif de l'Union africaine. Mais la Cour a mis en place, dans son règlement de 2020, ce qu'on appelle une procédure de suivi d'exécution. Il est possible qu'un requérant dont la décision n'a pas été exécutée vienne saisir la Cour pour lui demander de rendre une ordonnance tendant à ce que cette question-là soit résolue et que l'exécution soit faite. Alors, qu'en est-il du futur de la Cour? Nous avons, après la création de la Cour, nous avons eu d'autres protocoles, notamment le protocole de la Cour de justice de l'Union africaine, qui a été adopté en 2003 et qui est entré en vigueur. Après cette Cour, il y a eu un autre protocole, celui portant statut de la Cour africaine de justice et des droits de l'homme. L'idée, à travers cette Cour, mise en place par ce qu'on appelle le protocole de Sharm el-Sheikh, est de fusionner les deux cours, la Cour de justice de l'Union africaine et la Cour africaine des droits de l'homme et des peuples. Cette Cour, selon le protocole, comprend deux sections, une section des affaires générales et une section des droits de l'homme. Pour comprendre quelle est la compétence de la section générale, il faut retourner à la compétence de la Cour de justice, puisque cette Cour de justice est compétente dans les litiges interétatiques relativement à l'interprétation du droit international. Elle a également pour fonction d'être une juridiction d'appel du tribunal administratif de l'Union africaine. Un troisième protocole de celui-ci de Malabo, en 2014, qui vient amender le protocole relatif à la fusion entre la Cour de justice de l'Union africaine et la Cour africaine des droits de l'homme. La particularité de ce protocole, c'est qu'il vient créer une nouvelle section, une section droit pénal international, et cette Cour va se retrouver donc avec 16 juges répartis en 3 sections. Une section affaires générales, une section droits de l'homme et une section droit international pénal. Cette section de droit international pénal elle-même est en 3 chambres, une chambre préliminaire, une chambre de première instance et une chambre d'appel. Voilà donc pour le futur de la Cour, ce à quoi on devrait s'attendre à l'avenir dans cette réforme juridictionnelle de l'Union africaine. J'espère que cette présentation a été utile. Je reste à votre disposition pour toutes les questions que vous pourriez avoir sur la Cour africaine. Je vous remercie.
Merci beaucoup à M. Raibon pour la brillante présentation, vraiment. J'ai eu la première question. Elle porte sur la complémentarité entre la Commission et la Cour. Et quand je lis les dernières lignes directrices qui ont été adoptées, parfois je ne vois pas les critères ne ressortent pas, qui sont clairs pour savoir sur quoi la Commission se base pour transférer les affaires. Parce que cette voie, elle semble être la solution aux problèmes que nous soulevons chaque jour. Les problèmes, disons que les peuples africains n'ont pas accès à la Cour à cause de la déclaration facultative. Alors, comment faire en sorte que cette voie soit vraiment utilisée et qu'elle soit clairement utilisée par le peuple africain? Est-ce qu'il y a des critères qui sont clairs et auxquels on peut s'attendre lorsqu'on saisit la Commission avec l'intention que l'affaire soit transmise à la Cour africaine? Merci beaucoup.
Merci. Merci Eric. Il y a une autre question.
Merci beaucoup pour la parole. Pour la bonne compréhension de présentation. Parmi les procédures que la Cour respecte, est-ce qu'il est prévu dans sa politique, est-ce qu'il est prévu l'étape de contre-vérification dans les pays membres en cas de besoin pour l'Union africaine. Et aussi ma deuxième...
Étape 2.
Donc, je pose la question, est-ce que parmi les procédures que la Cour respecte, est-ce qu'il est prévu aussi une politique de faire les contre-vérifications dans un pays de manière d'urgence que la Cour est intéressée?
Thank you very much. May I ask in English? Okay. Two very short questions. Is the court taking any diplomatic steps in order to try to get more ratification of the charter, more declarations, or at least less withdrawals of the declarations? And second question, I assume you are not able to speak about the diplomatic relationship with the host state, but can you elaborate a little bit more about the legal relationship with the host state, with Tanzania? Thank you very much.
Merci beaucoup. J'aurais également une question concernant l'exécution même des décisions de la Cour. Parce que comme nous le savons très bien, c'est qu'il est prévu des mécanismes politiques où les décisions de la Cour peuvent être exécutées par les organes politiques. Ça peut être la conférence ou bien voilà, les mécanismes de suivi, la conférence ou bien les conseils exécutifs de l'Union africaine. Alors j'aimerais savoir, avec cette perspective qui a été faite de la Cour, pour que la Cour elle-même puisse chaque fois faire des suivis de ces décisions avec l'amélioration des règlements intérieurs même de la Cour. Je ne sais pas, l'article 81, est-ce que ça aille à donner quelques changements concrets sur le terrain? Parce qu'on a vu que confier les questions judiciaires voilà, donc confier les questions judiciaires à un organe politique, ça n'a pas vraiment tenu. Est-ce qu'avec les changements actuels, avec la mise en application et les suivis des décisions par la Cour elle-même, est-ce que ça a pu changer? Est-ce que ça a pu faire augmenter l'exécution des décisions de la Cour?
Well, thank you for your presentation. My question, the question I wanted to ask is, if I heard you correctly, at some point the court will be transformed and merged with the African Court of Justice. Now, if this court now, we see that only 3%, as you've said, of implementation has been done, then what will make that African Court of Justice do better than this one? That's the first question. And second, I would like to know to what extent the jurisprudence of the African Court of Human and People's Rights has influenced human rights within different states in Africa.
C'est bon, je peux commencer. Alors, pour la première série de questions, merci. Merci pour ces questions. La première question relative aux critères, je dois rappeler, je suppose que vous le savez déjà, puisque c'est pour cette raison que vous posez la question, il y a eu une retraite conjointe entre la Cour et la Commission en 2025. Et à l'issue de cette retraite conjointe, ont été adoptées ce qu'on appelle les lignes directrices en matière de renvoi ou de transfert. Je dois à la vérité de dire que les critères en tant que tels n'ont pas encore été déterminés. En tout cas, pour l'instant, il s'agira de régler les questions au cas par cas. Il n'est pas exclu, puisque la complémentarité est un processus work in progress. Il n'est pas exclu que dans un avenir très proche, que les critères puissent être établis. Toutefois, cela n'empêche pas la Commission de saisir la Cour d'une requête. Et c'est déjà arrivé, avant même qu'on ne parle de ces retraites conjointes ou de lignes directrices, la Commission a eu à saisir la Cour contre le Kenya, et cela a donné lieu à l'affaire emblématique OGEC, le peuple OGEC, le peuple autochtone. Elle a également eu à saisir la Cour contre la Libye, mais malheureusement, ces affaires avaient fait l'objet d'une radiation. C'est dire que même en l'absence aujourd'hui de critères de renvoi définis, de critères dans les détails, il y a déjà un cadre qui est là, c'est l'article 5 du protocole, qui donne la possibilité à la Commission de saisir la Cour. Rien n'empêche quelqu'un de saisir la Commission et de lui demander également, autant que faire se peut, de saisir la Cour. La Commission est un organe autonome. Elle appréciera la nécessité ou l'opportunité de saisir la Cour. C'est à ce stade que nous en sommes pour ce qui concerne la complémentarité, du moins en ce qui concerne les aspects judiciaires de la complémentarité, parce qu'il y a d'autres aspects non judiciaires dans cette complémentarité-là. La deuxième question, c'est la vôtre, je crois. Les procédures, vous avez parlé de contre-vérification. Je suppose que vous voulez parler d'enquête. C'est tout à fait prévu par le règlement. La Cour a la possibilité, lorsqu'elle est saisie d'une affaire, de procéder à des enquêtes sur place. C'est tout à fait possible. À l'heure actuelle, la Cour ne l'a pas encore expérimenté, nous ne l'avons pas encore fait, mais rien n'exclut que dans une affaire dont on est saisi, que la Cour puisse procéder à cette enquête lorsqu'elle estime que le dossier qu'on lui a présenté, que les arguments des parties ne suffisent pas à établir la réalité des faits qui viennent sous-tendre les violations alléguées. C'est donc prévu par le règlement. La Cour peut bel et bien procéder à des enquêtes et elle désigne un ou plusieurs juges aux fins d'y procéder. Ça fait partie des modes d'obtention de preuves. La troisième question concerne la diplomatie. D'une part, la diplomatie avec les autres États et de façon plus restreinte, la diplomatie avec le pays hôte, n'est-ce pas? Alors, avec les autres États, ce que nous faisons, nous entreprenons ce que nous appelons des visites de sensibilisation. La Cour, évidemment, il faut que l'État accepte cette visite. Nous saisissons les autorités étatiques et souvent l'autorité, la plus haute autorité d'un État donné, pour lui demander, pour lui dire que la Cour est disposée à effectuer ce qu'on appelle une visite de sensibilisation dans son pays. Et au cours de ces visites, ce qui se passe, c'est que nous allons rencontrer les plus hautes autorités, les autorités qui ont pouvoir de décision pour que le protocole soit ratifié ou que la déclaration soit faite. Comprenez par là le chef de l'État, le ministre des Affaires étrangères ou le ministre de la Justice. Mais également, nous allons rencontrer des gens de la société civile. Nous organisons des séminaires à l'intention de tous les acteurs de la justice pour qu'ils comprennent davantage ce qu'est la Cour. Parce qu'une chose est de demander à un État de ratifier le protocole ou de faire la déclaration, mais une autre est également de faire comprendre à cet État la nécessité d'y procéder. Et cette nécessité, nous l'entrevoyons à travers la compréhension que nous donnons à ceux-là que nous sommes allés visiter, cette compréhension du rôle de la Cour, du travail de la Cour. Ensuite, en ce qui concerne l'État hôte, nous avons des relations, je vais dire, normales. Nous avons ici des locaux dans lesquels nous travaillons et pour l'instant, en tout cas, nous n'avons pas senti que nous sommes à l'étranger. En tout cas, nous sommes dans un pays qui a pu donner à la Cour des locaux et nous faisons notre travail correctement. Alors, parlant de c'est bon, l'autre question, ça concerne l'impact des décisions de la Cour au niveau des États africains. Certains États africains ont procédé à ce qu'on pourrait appeler une transposition de jurisprudence. Ils ont eu à faire référence à certaines décisions de la Cour, notamment en matière de liberté d'expression. Je veux citer des États comme le Kenya, l'Afrique du Sud ou le Lesotho. La liberté d'expression n'est pas le seul domaine dans lequel ces décisions ont été transposées. Ces décisions de la Cour ont également concerné les questions relatives aux droits politiques, notamment d'interdiction des candidatures indépendantes, l'affaire emblématique Révérend Mtikila contre République de Tanzanie, où des juridictions nationales se réfèrent à la jurisprudence de la Cour pour pouvoir asseoir la décision qu'elles sont appelées, ces juridictions, à rendre. Ça montre un impact concret du rôle de la Cour, de la jurisprudence de la Cour au sein des États de l'Union africaine. Et pour procéder à cette transposition, on n'a pas besoin forcément d'être un État qui a ratifié le protocole ou un État qui a fait la déclaration. La jurisprudence, elle est disponible en ligne. Il suffit que les juges nationaux aient cette volonté, que cette situation puisse régler le problème qui leur est soumis pour qu'ils puissent y procéder. Alors, il y avait une autre question également sur l'exécution des décisions. Nous avons mis en place une procédure de suivi d'exécution. Est-ce que cette procédure a amélioré le taux d'exécution? Honnêtement, je vais dire certainement pas. Mais je pense qu'il est toujours utile, qu'il y aura certainement un impact dans un futur proche. Parce que le fait pour un État de savoir qu'une question a fait l'objet d'une décision de justice et que cet État n'a pas exécuté la décision, le fait pour cet État de savoir qu'il pourrait être attrait à nouveau, puisque cette affaire n'a pas été exécutée, je pense que cela pourrait, dans un futur assez proche, avoir un impact. Mais statistiquement, cette question, cette procédure, en tout cas pour l'instant, n'a pas apporté une nette amélioration de l'exécution des décisions. Mais nous espérons que dans un avenir proche, cela pourrait être fait. La dernière question vient de ce que concerne la fusion de la Cour de justice de l'Union africaine et la Cour africaine des droits de l'homme. Je reformule la question pour être sûr que je l'ai bien comprise. Puisque la Cour africaine, en tout cas, le travail de la Cour n'a pas beaucoup de travail, qu'est-ce que ça pourrait changer qu'on fasse une fusion ou qu'on mette en place une Cour de justice de l'Union africaine? Je pense qu'il faut d'abord se placer sous l'angle de la compétence de ces deux juridictions parce qu'elles ont des compétences différentes. La Cour africaine, sa compétence est fondée sur l'article 3 du protocole qui lui permet de connaître de toute affaire relative à des allégations de violation des droits de l'homme. Ces violations des droits de l'homme étant protégées par un instrument de protection des droits de l'homme ratifié par l'État défendeur. Tout autre est le cas de la Cour de justice de l'Union africaine. La Cour de justice de l'Union africaine a une double compétence. La plus simple, c'est celle de servir de juridiction d'appel au tribunal administratif de l'Union africaine. À Addis Abeba, il y a un tribunal qui est chargé de régler le contentieux entre le personnel de l'Union africaine et l'Union africaine elle-même. De manière générale, disons que ce tribunal a le rôle d'interprète du statut et du règlement du personnel de l'Union africaine. Ça, c'est le premier pan de la compétence de la Cour de justice de l'Union africaine. Le deuxième pan, c'est une compétence en matière de droit international général, mais dans les litiges interétatiques. Devant la Cour de justice de l'Union africaine, on peut invoquer tout instrument international, que ce soit un instrument de portée générale, adopté dans le cadre de l'Union africaine ou dans un autre cadre, pourvu qu'il s'agisse d'une question de droit international entre deux États. Et c'est là la distinction entre les deux juridictions. On me dira, oui, il est possible qu'il y ait une procédure interétatique devant la Cour africaine, cela est exact, mais la Cour africaine ne peut pas connaître d'une procédure en dehors de celle relative aux allégations de violation des droits de l'homme. Cela veut dire que même lorsqu'il s'agit d'une procédure interétatique devant la Cour africaine, cette procédure, elle est sous-tendue. Elle suppose l'existence d'allégations de violation de droits de l'homme spécifiquement. Donc, à partir du moment où il y a une différence quant à la compétence de ces juridictions, l'impact, une cour ne peut pas avoir en tant que telle un impact sur une autre. Et ce n'est pas parce que la Cour africaine n'a pas atteint ce que je pourrais appeler sa vitesse de croisière qu'il faut pour autant se décourager et ne pas créer d'autres institutions judiciaires au sein de l'Union africaine. J'espère avoir répondu à vos attentes, en tout cas relativement à ces questions. Il y a d'autres questions?
Thank you so much. A round of applause for Mr. Raymond. Merci beaucoup. Is there any? All right. Yeah. So we'd like to know if is there anyone who is not in the WhatsApp group? Because there are some relevant information that will be shared tonight, so we have to make sure that you all are in the WhatsApp group. Okay, so wishing you a beautiful evening, and let's catch up tomorrow morning. Thank you so much.